Penat tu. Aku lupa tu. Aku kena tengok video Torts tu. Baru aku boleh siapkan assignment aku. Bapa malas tu. For science, man. For science.
Assalamualaikum warahmatullahi wabarakatuh. My name is Anas bin Ahmad Zaharin, and I, on behalf of Legal News Station 3, will be reporting on breaking news. Breaking news: businessman caused voluntary hurt to an innocent Bangladeshi's face. The Bangladeshi was a mechanic working here in Kuala Lumpur. The occurrence happened on October 9, 2017 at 5 p.m. But who are the parties involved? Mustaza Muhammad Sharif was sentenced by Magistrate Rahni Kartini Abdurrahim for committing an offence against Jahid Molla, the previously mentioned innocent mechanic working at Cheras, more specifically Taman Maluri. The offence was committed under Section 323 of the Penal Code, which provides an imprisonment of no longer than 1 year and a fine of no more than 2,000 ringgit and or both. Section 323 of the Penal Code reads, whoever, except in the case provided for by Section 334, voluntarily causes hurt, shall be punished with imprisonment for a term which may extend to 1 year or with a fine which may extend to 2,000 ringgit, or both. But ladies and gentlemen, the real question is, can the actions done by Mustaza be considered an intentional tort of trespass? And if so, what trespass would it be categorized as? Here we have Jahid Molla's brother, who is a first-year law degree student at IIUM. He is an excellent student as well as a deanless student, and we intend on asking him his legal opinion as to what happened to his brother. Ali?
Yes, sir.
Now, according to the law of torts, this could either be trespass to person, trespass to goods, and or trespass to land. Could you tell us which and why?
Okay, so this is obviously not a trespass to good because that's not involve my brother's item, and also this cannot considered as trespass to land because that's not involve my brother's property. So I believe this is a trespass to person because it's actually a direct hit to my brother.
I see. And could you tell us why this is trespass to person more specifically?
Okay, so I think you can consider it as a battery because it is a direct force to my brother. Yeah.
All right. Thank you for your legal opinion. And that's all from 123 News. According to the plaintiff's brother, he believes that his brother Jahid Molla had suffered the trespass to person of battery. And according to our sources, this has been in fact confirmed. Battery has three elements, which are hostile intention, direct force, as well as unlawful justification. These three elements have in fact been fulfilled by the defendant. As for hostile intention, he has pleaded guilty to punching and slapping Jahid Molla, which does fulfill the second element as well of direct force through the punching and slapping. And there was no, in fact, lawful justification as to why he had conducted those actions, thus fulfilling all the necessary elements to battery.
Gosh, that was so boring. Oh my god. I think, let me search it on YouTube. I think I'll find a better video on this for trespass to person on YouTube.
Assalamualaikum warahmatullahi wabarakatuh. Welcome back to episode 34 of Learning Legal with Anas. Today we will be going over the topic of battery, and we will be discussing the case of KN, a child and another, versus Public Prosecutor 2022. Now, the facts of the case reads as follows. The applicants were 17 and 16 respectively, charged under Section 323 of the Penal Code. But instead of telling you all the facts by myself, I think it's best that I tell you the charge preferred to the applicants, which reads as follows. Bahawa kamu bersama-sama pada 8 Mac 2021, jam lebih kurang 6.20 petang di lorong belakang berhadapan SMK Tun Fatimah Hashim, Jalan Nibong 48, Taman Daya, di dalam daerah Johor Bahru Selatan. Di dalam negeri Johor dan dengan sengaja mendatangkan kecederaan ke atas lelaki nama Thiro anak lelaki Balasubramanian dengan menampar di bahagian muka. Oleh demikian, kamu telah melakukan satu kesalahan dan boleh dihukum di bawah Seksyen 323 Kanun Seksaan, dibaca dengan Seksyen 34 Kanun Keseksaan. Now, the initial punishment given by the courts was not only upon the advice of the Deputy Public Prosecutor, however, also upon the advice of advisors from the Court of Children, which was Rm 5,000 ringgit in default of 6 months of imprisonment to the parents of the applicants. Now, the reason behind this was because Section 323, despite having a maximum fine of Rm 2,000 ringgit, was in fact read with the Children Act, paragraph 91 to be specific, which allows a fine to be imposed with no maximum amount actually specified. Now, the applicant's case was that they contended the punishment because the fine given was in contrary to Section 323 of the Penal Code. Their arguments were supported by case law, as well as they relied on the maxim of generalia specialibus non derogat, which says that courts prefer specific provisions over provisions of general application. And in this case, they were trying to argue that the Children's Act was a general act as opposed to the Penal Code, which was more specific. The courts actually disagree with the agreement given out by the applicants, as they have stated that the Penal Code is a general provision and the Children's Act is actually the specific provision in this case. However, this did allow them to then review the long title of the Children's Act, which led them to humbly believe that the Parliament could not have intended for children to receive a higher fine in accordance to Section 323 of the Penal Code, in adjacent to adults that commit similar crimes. Now, a quote from the reasoning in the case review was, the long title of Children's Act 2001 stated that it is an act to provide for matters connected and incidental to care, protection and rehabilitation of children. In light of this long title, would the legislature have intended for children to pay a heftier fine than adults for the same offence, which then allowed the courts to decide, no, children should not have heftier fines than adults. This understanding that the Parliament could not have intended for children to receive heftier fines than adults despite committing the same acts of violence under Section 323 of the Penal Code has actually made the courts substitute the order to a fine of Rm 1,000 ringgit in default of 1 month in prison, as opposed to the initial punishment of 6 months imprisonment in default with an Rm 5,000 ringgit fine. With that, I hope you understand this case that I had summarized to you, and don't forget to like and subscribe to the video. Thank you.
I just remembered I got a podcast next week. Well, it is a Law and Order podcast, so I need to find some cases, some article regarding the newspaper cut that I just got. Yeah, I think I'm just gonna go on YouTube and search for it. Assalamualaikum and a good day to everyone watching this video. I will be explaining on a case related to the newspaper story that we have taken, which is regarding assault and battery. This is the case of Shalini P. Shanmugam and another against Marni binti Anjim. I will give you a quick head up on summary of facts of the case, where the case was regarding an appeal against the Session Court judge's decision. The court had previously allowed the plaintiff's claim for special and also general damages. The plaintiff acting as the respondent was an Indonesian national, and in June 1999, she worked for the second defendant as a domestic helper. The first defendant was the wife of the second defendant. The respondent claimed that she was exposed to moral degradation, verbal and also physical abuse by the first appellant during her work with the appellant until she fled away. The abuses listed in the statement of claim included having her finger smashed with a hammer, being kicked, and being stabbed with a screwdriver. The respondent sued both appellant based on the aforesaid charges, claiming the damages listed above. So the respondent was seeking damages for injuries sustained as a result of the first appellant assault and battery. Meanwhile, for the second appellant, it was based on a breach of the respondent's employment contract with the second appellant, as well as a breach of a common law duty of care based on the specific relationship of master and servant. So, in their united defense, the first and second appellant denied that the first appellant had caused the injuries as the respondent has claimed. Now, moving on to the judgment of the case, it was held that according to the record of appeal, the Learned Session Court judge indicated that her decision was made without depending on the first appellant's criminal conviction. Of course, she had every legal right to do so, as according to a previous case of Chu Michael against Low Sharp Mao in 1994. She elected not to do so, however, since she believed that without relying on the first defendant's conviction, the respondent had established her case on the balance of probabilities. The first appellant's temperament was not calm, according to the evidence presented at the trial, and in reality, the second appellant testified that the first appellant was aggressive and had been bound over for good behavior following an altercation at the airport. The two physicians, which is Plaintiff Witness 1 and Plaintiff Witness 4, testimony genuinely spoke for themselves. The injuries were not superficial, and they were not injuries that one might cause upon oneself. It is simply not logical. The testimony offered adequate support for the respondent's testimony. So the general damages in the sum of 48,000 ringgit Malaysia, which is made up as follows: permanent scarring and excruciating pain due to hot iron injury. The damages total to 38,000 ringgit Malaysia, and injuries to the plaintiff finger caused by a hammer total to 10,000 ringgit Malaysia. Therefore, the damages given to the plaintiff was justified. Hi there. So together with me again on another episode, where in this episode I will be explaining and summarizing one journal article that I have read, and this article is from Oxford Journals by Oxford University Press, and this article was actually written by F.A. Trinidad, titled Intentional Thought, Some Thoughts on Assault and Battery. So what this article about is that it explains regarding intentional thoughts of assault and battery, which falls under the subject of trespass to person. In this modern era, it is not such a popular thought, not such a popular law, because it is harder to prove the elements, which leads this thought to usually fall under criminal law, where in criminal law, a public prosecutor will handle the case in order to get easier compensation and also damages for the victim. So this is also based on the inconsistency and confusion of the law itself, because we know in law of thoughts there are no statutes, so it actually depends on previous cases and also based on the judge's decision. So this article also made it clear to us that intentional thought can be used where the action falls. So if you cannot sue under criminal law, then you can sue under thoughts. However, one thing to take note is that battery in criminal procedure, sometimes it is not the same as battery in torts cases, where some cases of battery could fulfill the torts element but not the elements of crime. So this is where it is important to use the law of intentional thought of trespass to person in assault and battery. So the next subject that was discussed in this article was actually what the true meaning of battery and the thoughts. So there are 5 matters that have been commented on by the author that he thinks are important. So firstly is the ingredient of battery, which is direct act. So the author cited a statement from Lord Denning in Letang against Cooper, where Lord Denning said that injuries into trespass, direct damage or case, we divide the causes of action according as the defendant did injury intentionally or unintentionally. So it is also stated that if this principle of common law was somehow removed, then it would simplify many other things. As common law stated by Selman, Lord Justice in Chick Fashion Limited against Jones, common law is a growing organism which continually adapts itself to meet the changing needs of time. So the author saying here is that he's thought that perhaps it is time to abolish the requirement of direct act in battery in torts cases, but however, it still serves some purpose in certain circumstances. So the second element, the important matter that the author discusses, is that intentional act, where the act must be intentional, where it is usually related to the voluntariness of the wrongdoer. So the intention usually does not consider whether there will be an injury towards the plaintiff, as long as the act was in nature unlawful. So the third element is that contact with the body of the plaintiff, where we know in battery there must be contact. So it will not be discussed together with the fourth element, which is element of knowledge of the context, because it is one of the main elements. So there's no need to explain it furthermore. And the last element that are discussed by the author, where he speaks for if there were consent given on the act, then there would be no battery. So we know that in order for battery to succeed, the victim must not given consent to the wrongdoer. So the main issue for this topic is whether the existence of consent shall be proven by the defendant or actually the plaintiff. And also further into the article, the author briefly explained some ingredients that are usually regarded by the court on assault, such as definition of direct threat as assault, where direct threat is a threat made by someone without actually doing it. And subsequently, the meaning of reasonable apprehension was also given by the author in the article, which is to anticipate with fear or with knowledge. And the last part of the article on assault, the author stated that knowledge of threat was also mentioned, where the plaintiff must have knowledge of the assault against battery, where in battery you don't even need to have knowledge for that. It is on the basis that you cannot fear someone without them knowing. So this sums up the article that I've read. This is a very good article, and I actually recommend everyone to read this.
Assalamualaikum warahmatullahi wabarakatuh. Welcome back to Law and Order, the Malaysian podcast where we break down all things legal here in Malaysia. I am your co-host Anas with our main host Haniff. So, did you hear about that news report that happened over the weekend?
Yeah, I did.
There was a businessman who punched a Bangladeshi.
Yeah.
Okay.
He got punched and slapped. Yeah, that was kind of messed up.
Okay. I feel like it looked like kind of racist. To macam,
Yeah,
so what can you do it?
but I don't really think about race or anything. I don't really think there's even any justification for that.
Yeah.
Okay, so today, since we are in Law of Order podcast, so Anas, what do you think? Do you have any legal analysis, something like that?
If I had to give some legal analysis, over the weekend I read a case. It was KN and another versus public prosecutor, where it was like these two children who hit some other kid in front of school, and the fine that was imposed to them was RM 1,000 ringgit because they were children, right? And a default of 1 month of imprisonment. So I feel what happened to the businessman, I believe his name is Mustaza. He actually got RM 2,000 ringgit fine. Yeah, I feel that is justified because he's an adult, and those children are 17 and 16, so they don't deserve as bad. So I feel it was justified.
But okay, he got fined for 2,000 ringgit. So what do you think about the law itself? Like, he was convicted under Penal Code 323, right?
Yeah.
So what do you think about it?
If I had to give comments and improvements on what Malaysia should be doing in order to improve, frankly speaking, is to increase the fine and the punishment, imprisonment.
Like just a little bit or like really high?
If I was a policymaker, I would increase it for adults to RM 5,000 ringgit, and for children RM 2,500 ringgit. For adults, I would throw them in prison for 1 year. For children, I would do about 6 months. And honestly, the reason why I would make it so harsh is because we have to deter our people from wanting to do crimes. If I only got 2,000 ringgit fine for slapping someone,
Yeah,
exactly. You know what I'm saying?
you can go around and
Just slap people.
anybody.
Yeah, it just paid 2,000 ringgit. It's like doing it for, you can do it if you're rich. You know?
Sure.
Yeah. Do you have any legal analysis as to what happened?
Well, actually, before I came here, I already searched for a case.
Yeah.
I can prepare.
No, you can
So,
prepare.
it's actually the case of name. The plaintiff was Shalini P. Shanmugam, and also another against Mani binti Anyi. So it's actually quite similar to our story today, which is regarding punch and slap for battery case.
Yeah, battery case.
But actually, it's worse in the case that I found. The plaintiff was actually a domestic helper.
That's rough.
He got kicked, he got stabbed with a screwdriver, and even got his finger smashed with a hammer.
Yeah, what happened?
Wait, let me recall it. So like the judgment of the case, the court said that the judge didn't follow criminal conviction because there's enough proof to show that the defendant was liable under torts. So like actually the court decided under torts law.
I see, okay. Do you have any improvements and or comments you feel about what happened?
I don't really think I have improvement for the law itself, but I think that for the case of Mustaza Muhammad Sharif and what is it? Jahid Mola.
Yeah.
Jahid Mola. I think Jahid Mola can actually proceed with Mustaza according to law of torts, because it's also on battery, it's under intentional torts. So I think he can sue Mustaza for the punching and slapping under battery. I think he can prove
I think he could.
I think because like some of the elements like direct force, like no
intention.
lawful justification and that. I don't think Mustaza slapped him for a reason.
Yeah, I don't think so. Hey, Jahid, if you need a lawyer, we can help.
We got you.
We can help. Before moving on to our next segment, here's a few words from our sponsor.